Hey everyone, today we are going to study the very important concept that is presumption in the court of law. Imagine a young bride dies mysteriously within a few years of her marriage, bruises on her body, whispers of dowry demands, and the family left in tears. The question is, who will prove the crime when the victim is no longer alive? Here's where Indian law steps in with a powerful presumption under the section 118 of the Bharatiya Sakshya Adhiniyam 2023, a provision that brings hope for justice in dowry death cases. So let's break down it step by step with an example. So first of all, let's see what is the presumption in law. In law, a presumption means that the court will assume something is true unless it is disproved. There are two types in this: may presume, that is optional for the court, and shall presume, that is mandatory for the court. If it is a may presume, that means it's optional for the court to presume or not to presume. But if it is shall presume, then it is a mandatory for the court to presume that particular thing has been happened. In section 118 of BSA, the wording is shall presume, meaning the judge is legally bound to presume dowry death if certain conditions are met. So what are these conditions? Let's see step by step. First one is if a woman dies an unnatural death within 7 years of marriage and it is proven that she was harassed or tortured in connection with dowry demands soon before her death, then the court shall presume that the husband or in-laws caused her death. So let's take real life example. Let's say a Priya, a 26-year-old woman, dies by burning just 3 years after marriage. Her parents testify that she called them often complaining about how her husband and mother-in-law demanded a car and harassed her for not bringing it. If this evidence is solid, the court must presume the accused caused her dowry death even before full trial. Now let's talk about what the changes have been made in old law and new law. That is, old law is the evidence law, and now that is new law on evidence that has been enforced, that is Bharatiya Sakshya Adhiniyam. So let's see what has been changes in old law and new law. Under the Indian Evidence Act, the presumption of dowry death is given under section 113B. It has now been directly carried forward as section 118 in Bharatiya Sakshya Adhiniyam 2023. There is no change in content, just the legal framework got updated under the new criminal laws. This also works alongside section 80 of the Bharatiya Nyaya Sanhita 2023, which defines what exactly amounts to dowry death. Section 80 of BNS. What is the dowry death? As per BNS, if a woman dies of burns, injury, or under unnatural circumstances. Second is within 7 years of marriage and it's shown that she was harassed or tortured by her husband or his relatives. The death occurred due to dowry demand, that is most important point in this condition, then it qualifies as a dowry death. So what is the punishment given in this? Punishment minimum 7 years imprisonment, may extend to life imprisonment. Now we will discuss some landmark cases. First one is the Kamesh Panjiyar versus State of Bihar, that is the 2005 case. In this case, Supreme Court held that once prosecution proves cruelty in connection with dowry and unnatural death within 7 years, the burden shifts to the accused to prove their innocence. The next case is Sher Singh Partapa versus State of Haryana, that is of the year of 2015 case. In this case, court clarified that presumption under law is not automatic conviction. It's just a starting point. Accused can still rebut it with evidence. Now here the question is arise, what does soon before death means? So the term is not rigid, it's contextual. Example, if a woman was last seen arguing about dowry 3 days before her death, it said a soon before death. Even if it was a few weeks ago, courts can presume connection if the evidence shows continuous harassment. Now here one more term that we have to discuss, that is burden of proof reversed. What it means? Usually prosecution must prove guilt, but under section 118, once cruelty and unnatural death are shown, accused must prove innocence. In this situation, we take an example. If a woman is found hanging and evidence shows dowry harassment, so in this situation her husband must show that the death was natural or accidental. Otherwise, court presumes guilt. Here we summarize our discussion. What is the main crux of the presumption of dowry death? First, we studied before that women died unnaturally, burns, injuries, suicide, etc. And it must be within 7 years of marriage, and evidence of cruelty, harassment for dowry also there, and harassment occurred soon before her death, and accused is her husband or his relative. If all these situations are fulfilled, then court shall presume dowry death. Now question is arise, why this provision is matter? Because dowry death cases often lack direct eyewitness. That's why this presumption fills the evidentiary gap and ensures that justice does not die with the victim. The court becomes active protector of rights, especially for women trapped in abusive marriages. Dowry is not just a social evil, it's a silent killer, and Section 118 of Bharatiya Sakshya Adhiniyam gives voice to those silenced forever. Let's educate, spread awareness, and support legal provisions that seek justice for the voiceless victims, because behind every dowry death is a system that must not fail her. This was our today's discussion on our particular topic is presumption of dowry death. Most importantly, don't forget to like, share if you learned something new today, and comment below what's your opinion on this particular topic. Subscribe for more simplified legal videos. So that's it for today. We will meet with our next topic with another video. Till then, keep learning and watching my videos. Thank you.